Okay. So let's talk about some of the statutes and laws, focusing on federal law here, um, as it relates to accountants and liability to their clients and third parties. Okay, so it's difficult to talk about accountants' liability without talking about Sarbanes-Oxley. It is the single most expansive piece of legislation governing accountants' liability, and it did so much, right? To place it in context, the Sarbanes-Oxley came in 2002, 2003, and it was the reaction to several high-profile accounting failures, namely Enron, which was audited by Arthur Andersen, and very heavily overvalued. And when Enron collapsed, or when the fecal matter hit the fan with Enron, a lot of people lost a lot of money, and many people also lost faith in the system of assurance, i.e. the audit process. So Sarbanes-Oxley was signed into law. It was named for the two congressmen, who were instrumental in getting it passed in record time. All right? So that's the genesis behind Sarbanes-Oxley. To be clear, it bifurcates audits into audits for public companies, publicly traded companies with assets in excess of $75 million, and then everybody else. All right. And so if you work in public accounting, either you do SOX clients or you don't. And that's the same, that could be said for accounting firms. Some accounting firms don't do SOX audits. They don't have clients audits that are subject to Sarbanes-Oxley or PCAOB compliance. Right. And I said PCAOB, that's the Public Company Accounting Oversight Board. And this was formed with Sarbanes-Oxley. Right? And what they do is they hire managers from public accounting, usually senior managers that would be close to being partner, and they audit the auditors. They will review working papers and interview audit teams for practices, policies, and procedures to make sure that audits are in fact being conducted per Sarbanes-Oxley. All right? And that's the main role of the PCAOB. All right? It is worth noting, and you should have been able to figure this out by now, Sarbanes-Oxley, or sometimes 404 audits are more expensive. I mean, it makes sense anyway, because usually you're talking about larger companies, larger clients that cost more to audit, require bigger audit teams and more sophisticated audit procedures. But this does increase the cost of compliance. All right, and the goal is that audits should mean something, right? And if you've had your audit class, you know that this means that not only does the auditor, the audit team express an opinion on the financial statements, but they also express an opinion on the internal controls present and surrounding the financial statements. All right? Working papers. For Sarbanes-Oxley clients or SOX clients, working papers are retained for 7 years, and in most firms, not a week longer. All right. Oftentimes they're digital, it makes it easier to manage. But if there is any hard copy, they have to be retained for 7 years, which is what the Sarbanes-Oxley requires, and then they would be purged. All right. So we'll talk about the 1933 Act. Again, to place this in context, in 1933, the United States was climbing out of the Great Depression, which was the result of the stock market crash in 1929. And the Securities Acts of 33 and 34 were in that vein. They were part of the government's initiative to encourage individuals to feel comfortable investing in securities. Once again, since that really is essential to business in the United States. All right, so the Securities Act of 33, it did a bunch. We're not going to get into all that it did. You have the historical context, but let's talk about Section 11. All right. So imposes civil liability on accountants for misstatements and omissions of material facts in registration statements. And pretty much anybody who purchases a security covered by that registration statement can sue the accountant for material misstatements or omissions. All right. The strongest defense that the accountants have when they are sued under Section 11 of the 33 Act is that they employed what we'll refer to as due diligence, which really is a standard of care. Right? The actions of the accountants were reasonable. They conducted a reasonable investigation, and they had reasonable grounds to believe that the registration statement that they certified was true at the time it became effective. So that is what makes up due diligence. All right. Other defenses, and they're kind of quick hitters. There actually were no material misstatements or omissions. In other words, if the registration statement was accurate. When we say registration statement, we're talking about the document that would be issued as part of an initial public offering, bringing shares of stock to the open market for trading. Second argument, omitted or misstated information was not material to the financial statements. All right. In other words, it's not that important. It's a smaller threshold issue. And this one should sound similar. Omitted or misstated info was not the cause of the plaintiff's loss. In other words, something else is happening here. Or plaintiff knowledge of the misstatements. You knew that there were misstatements and you invested anyway and lost. So that's not, we shouldn't hold the accountant liable for that. All right. Section 12(2) of the Act also allows for civil liability from fraud or omission of a material fact. Here, criminal charges may be appropriate. $10,000 or 5 years in jail. Okay. The 34 Act. And to place the 34 Act in context, it had the cases. If you think you can sue an accountant, you'd rather do it under the 33 Act because the liability is greater, the potential liability is greater, and the case is easier to make. Whereas under the 34 Act, you have smaller liability and a much more difficult case to make in court. All right, we'll talk about liability limits in just a moment. Let's talk about Section 18. All right. So the 33 Act really deals with the information in the registration statement. So the 34 Act deals with information in other documents and reports. All right. So for liability under Section 18, and again, it's a very expansive piece of legislation. We're just talking about two sections, 18 and 10B. Section 18 means there's a false or misleading statement that affected the price of a security or a stock on the open market, and that the plaintiff relied on that statement. Now, in this case, once these two elements are proven, the accountant to defend really only needs to show that they acted in good faith. Right? We've talked a little bit about good faith, which really means that they weren't trying to mislead the general public. If there was a misleading statement, it was purely accidental. All right, that's good faith. Section 10B, and the SEC has mirrored that in SEC Rule 10b-5. This is your device intended to defraud the public, the investing public. So it is illegal to employ any device, scheme, or strategy to defraud the investing public, to make any untrue statement or omission of material fact, or to engage in any fraudulent act with the purchase of any security. Right. So that is somewhat of a catch-all, but it is meant to target fraudulent or would-be fraudulent actions by the accountants as it relates to bringing new securities to market. Okay. In addition to civil liability under the 34 and 33 Acts, there can also be criminal liability to boot if any of these three are present, or oftentimes under state securities law, there can be criminal liability for knowingly filing false reports. All right, that is, I'm filing financial statements that I know are just wrong. All right. Falsifying, altering, or destroying accounting records. And I'll have to see if I can find this to post in the course, but there, in and around 2002, 2003, was the telephone wars. Right, and Sprint's advertisement was Sprint PCS, which really meant Sprint Pretty Clear Sound, and it kind of speaks to how far we've come with cell phone service, because now the selling point is data speeds, but in 2002, 2003, it was how clear of telephone calls you got, and apparently there were differences from one network to the next. And so an ad that ran in Newsweek and The Economist was a Sprint ad, and it said, and the gist of the ad was, and it was poking fun at Arthur Andersen, right? And it says, when you thought you said, or when you said, send those documents over to the feds, but what the person on the other end of the line hears is rip those documents to shreds, well, you should have been on a Sprint phone, right? So that's the idea, is that the message sent was not the one received, and as a result, Arthur Andersen, of course this is hyperbole, but Arthur Andersen was shredding and destroying documents, and as a result, that is, well, it was illegal then. It's definitely illegal now. And using false statements, false financial statements to obtain property or credit. Okay. So, criminal liability limits under the 33 Act, 5 years, $10,000. 34 Act, up to 10 years and $100,000. For Sarbanes-Oxley, there's some serious teeth in it, right? It's designed. Keep in mind, Sarbanes-Oxley was 2002, 2003, so you're looking at about 70 years later, and Sarbanes-Oxley was laser focused on restoring accountability and credibility to the accounting profession. All right. And so it has some teeth. $5 million and or 20 years. And those aren't exclusive. You can get both for violation. Both the $5 million fine and the 20 years in jail for violations of Sarbanes-Oxley. All right. And of course, you see the IRS criminal liability for filing false return, $100,000 per return or $500,000 for corporate returns. Okay. Let's talk about privileged communications. All right. So the ultimate privilege is attorney-client privilege. And it's actually quite simple. Once you retain an attorney, anything you tell that attorney is privileged, and that attorney cannot be legally compelled to break that confidence. In fact, even if the attorney wants to, their professional rules preclude them from breaking client confidence. They can get in a lot of trouble for doing that, intentionally or accidentally. Very few states, Ohio is not one of them, has the concept of an accountant-client privilege, which is the exact same thing. Whatever you tell your accountant, the accountant can't be compelled to reveal in court. Well, that's obviously much weaker because it's not even recognized but in 4 states: Pennsylvania, Florida, Colorado, and Missouri. So there's no accountant-client privilege in Ohio. If you tell your accountant something, your accountant could be compelled, or, standing in the shoes of the accountant, if your client tells you something that they're part of a larger fraud, you could be compelled to reveal that if you're subpoenaed in court. I wouldn't just tell it just because somebody asked. I would wait to be subpoenaed, but if you are subpoenaed, then you have no legal basis to not comply with that subpoena.